Item number 1, part admitter.
Well,
Yes.
I'm sorry for that 17. I've been suffering from fever. I put
What?
item number 1.
Okay. You're not well.
Although I'll finish it because simple matter is there. Part hard matter. I have to
Okay.
finish it because there is two things. Worship, yes. The disability, in regard to the disability,
Yes.
they could not prove the learned court below has justified. A second thing is that the income was accepted is 3,000.
Hmm.
So I also giving the endorsement is 5,000. That is enhanced another 2,000.
Hmm.
Regarding my lord, he has submitted
Hmm.
additional affidavit. That is IA 61,000.
Hmm.
That is my lord. I also discussed with my company.
Hmm.
So that considering all the aspect, because we could not verify during this period,
Hmm.
because it may be 50,000 maximum out of the, because
In IA.
IA that he has submitted some
Hmm.
document, because generally in the trial court,
Hmm.
more than 50,000 we verified.
Hmm. Hmm.
Then we adduce defense witness.
Hmm.
But in this regard, since it is a more than exceed the 50,000, so they said that 50,000 we have no otherwise, because we leave to dispose
We
of
can allow by giving 50,000
50,000. I have no
maximum.
maximum.
Okay.
That is-
Otherwise, you will require verification.
My lord,
Otherwise, you will have to verify.
otherwise verify. That is
Okay.
why
And then income, how much? Up to 7,000? Per
5,000.
5,000 per month.
Because 3,000 already accepted,
Hmm.
and hence another 2,000.
Hmm.
I mean, that means, my lord, same thing will be happen
Hmm.
if it is a disability accepted by the learned court, and also 2,000 as per.
Hmm.
So
Disability certificate they were able to prove or not?
65%.
Huh?
60%.
there is no signature. That is
Oh,
why.
yes. Yes, now I remember.
That is why the thing is there is no endorsement, not exhibited.
But
Although
medical study board already doctor signed dear madam. Understand
You see,
maybe,
well, legal
if you
position.
have to calculate, no?
Yes, madam.
You see that you have been given a very generous order, because why I'm saying that disability certificate,
Yes, madam.
it has to be signed by the medical
yes,
board.
authority.
Yes, madam. Already it is there.
Issuing
madam.
authority.
Medical board it is signed, but here legal position is different, my lord. In the year, my lord, that was the amount, my lord, what has been given by my learned.
He is saying that you have not exhibited disability.
No, salary,
Exhibited.
so far salary is concerned 10,000 it was given, my lord, prayed
But
for.
not proved.
But he,
It is
but,
clear.
2,000, my lord, whatever may be, but there was no cross-examination.
Salary was not proved.
Yes, my lord,
My lord.
not cross-examination. And so far disability is concerned, my lord. How can it be, my lord?
No,
Instead of,
if you are not proving the salary certificate, why they will cross
my lord,
examine?
legal position is
That is
different,
the
my
thing.
lord.
The
I have
findings
checked
of
the
the
law.
learned trial court very much clear with short statement.
Hmm.
Very clear. My lord, kindly see the 227 page number. Already it is completed. It was completed, that part. Although I'm being in the record, my lord, page 27, that is para number 6. As per the exhibit 85, the claimant appeared before the district standing medical board on 29/3/18 in order to assess the disability caused due to the alleged accident. The board, after consideration of the injury sustained by him, issued disability certificate exhibit 85, whereby declared that the due to injuries sustained by him was 60%, about 60%, about 60% permanent or temporary. This is very important. That is fluctuating. It should be permanent or temporary.
Correct.
Yes. There is a number of judgment, my lord. I'm not going to see this small case.
Hmm.
Then next, my lord, 7. PW2 has deposed a cross-examination that the quantum of disability may be decrease, and this is the findings of this on a learned court below, decrease in the passage of time. It may be decreased. Then from the medical evidence on record and considering the type of injury sustained by the claimant PW1, I am on the view that 25% accepted. The view that such injuries has caused partial disability,
Hmm.
not permanent, partial. Partial means it may fluctuated. because he has not given the along with his IA present status. Because every 3 years the assessment is going on as per the medical board. Then that the claimant become 25% physically disabled due to injury sustained by him in the claimant. As the claimant sustained 25% disability, aforesaid injuries, and for such disability, I would definitely reduce the earning capacity. That is the earning capacity also, because disability and loss of earning capacity. That is why he has, because earning capacity is not assessed. Both the things is required. Maybe I may be 100% disability, but I have a capacity to earn. I was doing some other job, but some other job, I shifted some other job. I can write it. That is the thing. Now question come, my lord, regarding the income. In the case in hand, the claimant has stated that he earned rupees 10,000 as his monthly income by doing motor mechanic. There is no proof motor mechanic. But the claimant has not brought on record any kind of corroborative evidence of substantiate his monthly income at rupees 10,000. It is also found that no any evidence tendered by the claimant to prove that he is technically trained skilled labor. Question is that whether he is a technically trained labor, he is working somebody else, under somebody else, nothing has been done. Although court has accepted 3,000. This is clear, my lord. It is small findings, but very vivid picture is there. That is why court has come to the findings. They accepted 3,000. That is also, for me, also another 2,000 maybe another. This is the two things. Disability 25%. And there might be, my lord, I cannot ignore these things. 50,000, because if it is that, again, I have to take time because of 50,000. Maybe judgment may be given. And my lord, since we have paid entire amount with the, it is on record with interest. So, my lord, 60 days may be given. We'll pay. If not fail to pay, then we'll pay 6% per year.
Okay.
This is my submission, because recently Justice Robin Pokon has given some one judgment also. I have not received in my case also.
About what?
About the interest.
Interest 6%.
6%. Because already we have paid, satisfied entire amount. Since satisfied, now it is a additional enhancement. So in this regard, if I fail within a statutory time fixed by this honorable court, then automatically I'll pay 6% interest from the date of judgment.
From date of judgment?
Today. If it is today, my lord, I'll pay.
No, today I don't think I'll have
No,
time.
anyway, I'm just submitting. Maybe CAB or whatever, maybe. I'll pay. Within 60 days, we pay. Generally, NF stay order, we pay sometime 25%, 50%, whatever, maybe 60 days is giving, or 45 days is giving. We pay. That is why. We'll pay. This is my endorsement, my lord.
But so far legal position is concerned, it is not absolutely different picture, my lord. Because, my lord, so far income is concerned 10,000, it will be reducing up, because in the year itself 2013, 2013 income source was there, my lord. I am passing this judgment, my lord. Yes, 6,500 was calculated in the year 2013, my lord, itself, as it was not considered, my lord. And disability, so far disability is concerned, it cannot be reduced, my lord. And this, my lord, judgment, Raj Kumar and Ajay Kumar judgment specifically mentioned what should not look into the diminishing factor, my lord. Because here, my lord, just I am reading this paragraph, my lord, it will be clear.
Which paragraph?
My lord, paragraph 7, my lord. Here, my lord, it is reproduced here in this judgment, my lord. Recent judgment 2024 6 SCC 149. This judgment, it is Raj Kumar, Ajay Kumar judgment, it is reproduced here, my lord. The tribunal should not be silent spectator when medical evidence is tendered in regard to the injuries and their effect, in particular, the extent of permanent disability. Section 168 and 169 of the Act make it evident that the tribunal does not function as a neutral umpire as in a civil suit, but as an active explorer and seeker of truth who is required to hold an inquiry into the claim for determining the just compensation. The tribunal should therefore take an active role to ascertain the truth and correct position so that it can assess the just compensation while dealing with the personal injury cases. The tribunal should preferably equip itself with a medical dictionary and a handbook for evaluation of permanent physical impairment. For example, manual of evaluation of permanent physical impairment for orthopedic surgeon prepared by American Academy or orthopedic surgeon or Indian equivalent or other authorities text for understanding the medical evidence and
Is
assessing.
it there, no? The Employees Compensation Act.
Yeah, workman compensation.
Now it has become Employees Compensation
Well,
Act.
one, there is
How to
a,
calculate the
there is a,
disability?
in workman compensation, there is a two types of assessment. One is a scheduled injury, another is a non-scheduled injury. Non-scheduled means fracture like this. Scheduled injury is something I cut my finger, hand like this. There is a mention percentage of injuries. The here is a, my lord, not.
Here you are saying that it has not been mentioned whether injury is permanent or.
Yes, that is a
temporary.
very important.
Here,
It is-
it is also different.
Whatever.
Mm.
Here is a, it is very much clear. So far I have gone through this record. That is, this audit code below has briefly narrated everything, because whether it is a temporary, but it is a permanent. If it is a permanent, that question is arises something different. If it is a temporary, there is separate question. It is not a permanent. That is why he reduced to, he is not make it zero. Make it zero, it is 25%. Even then in the disability certificate, there is a mistake. So far, if I be there, I will not accept the disability because he has not put issuing person. Has to be proved. This is the Mandatory Professional Evidence Act. The issuing authority has to be exhibited. That is not proved. Although it may be MSCT cases, it does not mean that otherwise proceeding is not required. Minimum standard of proof required. That is why I'm saying I'm not going to dispute any other things because he is entitled. Minimum he has to get it. That is why I have no any other thing.
Well, so far, this schedule of income is concerned. It is also in the recent judgment, 21-1 SCC for 25.
You give me the judgment.
Yes, I am giving all those judgment, Here, may I read this relevant portion, regarding that income. This court is also of the opinion that the courts below needlessly discounted the evidence presumed by the appellant in respect of the income earned by him working in financial sector as he did. That is to say, as a typist, data entry operator in court premises in Delhi, the assertion about earning of 12,000 could not be discarded substantially to the extent of bringing it down to 8,000 per month. Such self-employed professional, it is noticeable, were not obliged to file income tax return of the year 2011 to 12, which no levy existed for anyone earning less than 1,60,000 per annum. First Schedule Finance Act 2011. The advocate who deposed about the earnings of the appellant was believed to the extent that the tribunal fixed the appellant monthly earnings 8,000. If one takes into account the contemporary minimum wages for skilled worker, which was in the range of 8,500, the realistic figure was 10,000 per month, adding future prospect 40% by applying the ratio chronicity. That is also there, my lord. And another judgment, my lord, 14, I am marking here, 2023-13-54, my lord.
For what?
Regarding the, my lord, that enhancement portion, what are the ingredients, my lord, has to be considered. Here, my lord, disabled resulting, my lord, 100% loss of income, because
No.
here, yes, my lord.
No, that will not help you.
Yes, my lord.
This is 100% loss of income.
No, my lord, he is bedridden, my lord. And that is, I have specifically mentioned additional affidavit. What has been, my lord, already submitted by learned friend in my affidavit in opposition, my lord, additional affidavit. In page 3, in paragraph 4, I have specifically mentioned that what is his disease.
My lord, if it is so, my learned friend says, the facts and circumstances is totally different as per the my lord, authority.
Now, present status is different. Regarding this status, you have mentioned
Present status, you have narrated
mentioned.
given a statement, whether you have given the any assessment or doctor's certificate along with the IA? Nothing, because you are bank upon that exhibit, exhibit 86. If it is exhibit 86, you are stated now, that means it is a continuous process.
Where is the I?
Additional affidavit, my lord, it was filed, my lord, IA, my lord, 4185 to 1121.
Four one eight five has been disposed of.
Suppose of.
Now here I have mentioned, my lord, regarding that status, my lord. Page 3, paragraph 3, that under the aforesaid circumstances stated above, your deponent has filed the instant additional affidavit to bring on records the expenditures arising out of this accident took place on 27/8.
No, this I will not work.
Here, my lord. Further, your
Is
deponent is
bedridden, cannot bring it on record. So
Lordship?
this is for limitation.
no, already, my lord, that is there in the records. All the papers I have annexed here. Houses also. That is why my land friend has submitted that 61,000 instead of 61, 50,000 will be payable to me. So far, I would regard
On which record you have brought?
Lordship?
On which record? IA, the limitation case.
No, my lord, no, not I. 4185.
4185 has been disposed of.
Now that was the case for the bringing on record additional affidavit, that is.
Can it be, my lord? Delay petition, delay application.
No, this is delay petition.
Delay petition is very much specific, only for delay. Nothing has to be.
2/11/21 it was filed, madam. 2/11/21. By bringing the additional affidavit filed by the petitioner appellant in the above mentioned case, madam.
In which case? 2/11/21.
Yes, my lord.
In this MSC appeal.
Yes, my lord. Along with the MSC, possibly there was a delay condonation petition was also there, as it was not
Delay
registered.
condonation petition was
Along
disposed
with
of.
the possibly, my lord, as it was not numbered, MSC appeal was not numbered. As it was filed, it was for registration purpose. It was possibly in IA, is shown as possibly in the IA, my lord, disposal of 4185. That is that additional affidavit has been added there.
I don't think so. You can take up this matter now, which has been disposed of, and bring on record all this.
But it was filed on 2/11/21.
Oh, yes. There's an additional affidavit.
Yes. And that is why my land friend also.
Additional affidavit, okay. Yes.
Yes, madam. Because in MSC, it was appeal was not registered at that time. And much so far, my lord, this recent judgment, 24 judgment, I have already given to your lordship, my lord. In that judgment, everything it is considered, my lord. 17,000 disability was there. Instead of it was reduced to 10%, my lord. So, my lord, it was given the 17%. And so, for other aspect of the matter, I am giving the recent judgment, my lord. I also marked the paragraphs.
Okay.
Monthly income, disability, and medical expenditure. And so far disability is concerned, till death he is bedridden, my lord, according to me. 5 times operation, my lord, in Patna. That is why. He was a mechanic, so he is bedridden now.
Okay.
But this is all the judgment. He is supporting. Facts and circumstances totally different. Kindly see, how the enhancement of the disability. He said no permanent, whether permanent or temporary. The case is different. Case is different. Then present case, then his judgment. Totally different. Even then the income is not proved. It is written by the learned tribunal also. So whether the profession, he was a profession of mechanic or not, how we can say that? You saying that your statement that he is a mechanic. How you can prove it is your burden to prove that I am a mechanic. If you are working somebody else under somebody else, you have to give it is evidence to prove this. That is what the learned court come to the finding that they failed to prove this that he was a mechanic. That is why the court has come to the findings. And disability is totally different. Then I have gone through this type of cases. That is why I have not seen, because present case is totally different. If it is proved, then this applicable of the present, this judgment, some judgment. You have to prove it. Then not accepted by the learned tribunal, then may be enhanced, may not be enhanced. So case is different, my lord, totally different. Although, my lord, I am saying the 50,000 and also 3,000, 2,000 extra. And give it time, 60 days
You
time.
see this additional affidavit. So this is you are submitting one additional affidavit. Then you are
It was
submitting.
filed in the year 21.
I know you.
Yes.
This is a new case.
Yes,
This is an appeal. So these are the new circumstances.
Mhm.
How you will bring additional evidence in an appeal?
Well,
The
appeal-
order 41 rule 27,
Yes,
which you
exactly.
comply with.
yes.
So I'll pass an order accordingly.
Yes, my lord.
My lord,
And so far,
This
my lord,
additional affidavit will not work.
so far, my lord, this recent status is concerned. That is why, my lord, as client has, my lord, insisted.
No, you.
Insisted me,
you
I
know
have
the
already.
way to submit your recent status.
Yes, my lord. And
Order 41 rule
Rule
27.
27 is
that is
additional
correct, my lord,
evidence.
but cross examination also part is there, my lord. Your lordship peruse it.
Okay.
Doctor also, my lord.
Much obliged.
Much obliged, my lord.
আৰু এটা argument আছে না? Oh, এইটো। কি আছিলে? H. Das, Learned Counsel for the appellant and Learned Counsel.
Is that
Mr. R.C. Paul.
respondent number
Learned
1?
Counsel for the insurance company.
Yes,
Reserved for judgment and order.
much obliged. I'm sorry.
Even I also forgot to dictate because I have been sitting in the DB. Can we complete it today?
Yes, my lord. Wait, it will take only 5 to 10 minutes, my lord. Your lordship may kindly peruse the order dated 10 to 2026, my lord.
Order dated 10 to 2000?
Yes, my lord, 26.
My order?
Yes, my lord.
Okay. What is this?
They, as per that order, my lord, the hearing on the part of the other side is concluded. So his argument is concluded, so he cannot argue today. And only so far as my part is concerned, it was part heard, and I have only limited submission, only for remand, my lord.
But he can
Nothing
reply, no?
else.
He can reply.
He
Your
can
Honor, I
reply.
think she is very sorry to say that the submissions she made just now, because that is not the facts. If it is even reflected, Your Honor is pretty much aware what had happened. Your Honor had informed both of us that, okay, the arguments had completed. Next day, she was supposed to give a judgment. Actually, her argument was also completed.
my lord.
After that, I gave him a
Order
submit.
itself reflects. Your lordship may kindly peruse the order.
But that's something, integrity is there. I'm just saying what is the truth. I'm not lying anything. That's about, because some.
I am
there's
also
a-
not arguing.
No,
The only
no, no, no.
submission is so.
Sir,
Yes.
This is a clerical error. I didn't include that subject to the condition that he may be allowed to reply.
And
Only this much I didn't include in the order. Otherwise, he has every right to reply.
Yes, my lord.
I'm
that is
thankful,
my
Your
order.
Honor, that the matter is pardoned is before you. Otherwise, if it was in some other court and this statement was made, and then it would be an adverse.
Because the other day,
Understanding. This
the
is not
order
fair
was
at all.
uploaded, my lord. Whatever may be, my lord.
This is
My humble submission is that, my lord, my prayer is that only for remand. And so far as my prayer is concerned, your lordship may kindly turn to page 44 of my appeal, my lord. prayer is there, my lord.
Okay, for remand.
For remand, my lord, Father be pleased to, first part is for setting aside. Then page 44, my lord, the, my lord, second part is Father be pleased to pass any other order or further orders or direction as may be deemed fit and proper to meet the ends of justice. So your lordship may remand the matter for the ends of justice, my lord, so that the petitioner, the appellant may get a chance to prove herself, my lord, prove her case, my lord, as per provision of section 107 CPC, my lord.
Let's see if I don't think that there's any scope to remand, but let's see.
As per this provision, your lordship has a ample, my lord.
No. Remand will be like allowing you to fill up lacuna.
That is not there, my lord. In this part, my lord, what happened, my lord? Here,
When a case is remanded, when issues are not properly framed, then we can remand a case.
my lord, here what happened, my lord? My lord, the leaflet was not, my lord, exhibited. That is there, my lord. So far as the subsequent development regarding her reinstatement and all these documents, the appellant furnished to her counsel, but it was somehow not placed, my lord, or not produced, my lord, by way of, my lord, submitting additional evidence. So for the fault on the part of the counsel, my lord, the appellant may not suffer. This is my humble prayer, my lord. If it is, she is unable to prove herself this time also, then it is her bad luck. So at least one chance may be given.
I don't think so.
So only this much I have to say.
If I find any scope while dictating the judgment, I don't know, but for reducing additional evidence to remand, there has to be certain prayer in the appeal, and then there has to be mistake in framing issues.
Prayer is there, my
issues
lord,
are not framed.
father or
I
other,
don't
any
know,
other
but I
order.
haven't seen so far. Last time when we went to the record side, I haven't seen. So
Prayer,
if there is any, if I find anything, then maybe, but I don't think you have a good
but
case.
prayer is there, my lord. Any other or further orders, it may include remand also. Any order, your lordship, apart from setting aside. Then it is up to your lordship. Lordship may consider.
Yes.
This court definitely has the power to remand back. I'm not going into that because this is an appellate court, superior court. But your honor, the thing is that whenever I pray that the matter is remanded back, I have to show and I have to satisfy this honorable court why I want the matter to be remanded back. Suppose a document is there, it was in spite of due diligence, I could not procure the document, and then I seek the permission of this court. Then the court, after going through, and I have to show not only why I could not get hold of the document and why I did not produce it at the time of the trial. But in this instant case, there is no statement why I did not produce or why.
Statements are there. In my grounds, my lord, in each and every ground, I have repeatedly stated, my lord.
So,
and documents also the other day I have produced, my lord, but I've tried to show.
Why it could not be exhibited then at that time?
My lord, the appellant had placed all the documents, my lord, furnished all the documents to her counsel, my lord. And her first counsel, he expired, my lord. And the second counsel, who had taken over, my lord, then he did not, my lord, produce whatever may be, my lord.
These are all new facts, no reading in the documents, no application, appropriate application.
This came
These
now
are
only.
statements.
This fact, this point came up now only.
Court, or how will anyone
during the course of argument only.
Then there is no limit. I can say anything that I have this record which he has written me, a letter is there. he has accepted that I have defamed. So tomorrow, how will the court take?
You have
Well,
mentioned in
regarding the
petition,
fact
appeal
that
memo,
the
that
council
the-
has expired, it is a fact, my lord.
Have you mentioned in the appeal memo that the
Regard-
council has expired and the second?
My lord,
council-
during the pendency, my lord,
During the pendency of this case or
during the pendency of that court
have you mentioned in
case,
the appeal memo?
I have not mentioned.
No, this will not work. You have to mention in the appeal memo.
I should have mentioned.
No.
But regarding all the documents and all, I have mentioned in all my grounds, my lord.
I'll go through it. If there's a case to remand, I don't know. I don't think this is a case that
If there's some chances there, your
I
lordship
think
may
so.
consider.
there has to be some grounds to remand or to introduce new additional evidence. There has to be some grounds and additional evidence. Then you will have to file an application or you will have to mention it in the appeal memo. Definitely, you will have to mention it in the appeal memo.
Regarding the leaflet,
Remand is not required. to mention it in
leaflet
the
I have
appeal memo.
annexed in this appeal.
Hmm?
The leaflet I have annexed, on the basis of which
No,
action
this
was
will not
taken.
work.
And
This will not work. Annexure will not work. You will have to prove it through additional evidence. You see, either you have to prove before this court or before a lower court. I can direct
before
the lower court.
yes,
But here
court it was not placed.
have to have sufficient grounds. Without sufficient grounds,
And regarding her reinstatement and that all the allegations were proved wrong. And because of that, she was reinstated. So that itself proves that defamation is there. But only the thing, unfortunately, the documents, her reinstatement order and a High Court's order all were not placed at that particular time.
Even
before the
today it is
learned
not
trial
placed.
court.
Even today
No,
it is not placed.
yes, yes, it
Reinstatement
is
order,
here, my
where
lord.
Reinstatement order, show.
I don't know what.
Okay.
I don't know what business.